Dear friends, in this chapter in our course Social Welfare and Social Legislation, we will be looking at legislations and constitutional provisions in favour of women. What Chairman Mao said about women in China is equally true about women in India and indeed around the world. That is, women hold up half the sky. About 50% of the human race belongs to the female gender, but this is not properly represented in public, economic and political life. Not only is there a preponderance of men in these spheres, but there is also an active set of obstacles that the women have to overcome if they are to make an impact in what is essentially a male-dominated world. India struggles with this problem, particularly because the conditions of the women in our country are in a state that require immediate attention. It is seen in India that not only do women lag behind men in indices like literacy rate, access to higher education and employment, but also basic needs like health, access to medical care, nutrition, etc. Apart from all of this, there is an active physical abuse of women that is constantly going on, which may manifest itself as rape, molestation, domestic cruelty, etc. Further, women are perceived as having low social status and being a burden on the family they are born into. This leads to what is one of the most pressing problems of the day, that is, female feticide and infanticide, leading to a skewed sex ratio. In order to improve the conditions of women, the government and legislatures have taken several measures from time to time to bring in provisions and statutes that provide some help to women. We may see some of the constitutional provisions that have been enacted in favour of women. Article 15(3) of the Constitution of India provides that the state may make special provisions in favour of women. This is seen as being a part of the rule of non-discrimination. It has been interpreted not as an exception to non-discrimination, but as an integral part of that principle. At this juncture, I need to remind you that equality, as it is understood in the Constitution of India, does not believe in treating all people as equal. It believes in all people who are in similar conditions as equals. Therefore, treating a class of people who have been subjected to any sort of historical incapacity differently from the rest is not a violation or an exception to the rule of equality. It is merely another facet of that same rule. Perhaps the true concern that the Constitution has towards women is brought out through the chapter on directive principles of state policy. Article 39A of the Constitution says specifically that men and women are to be placed on an equal footing when it comes to the question of having a right to livelihood. This has been operationalized in several ways through government policy. The Mahatma Gandhi National Rural Employment Guarantee Scheme, which is an employment guarantee scheme that provides 100 days of employment in a year, has a stated preference for employing women. Swarna Jayanti Gramin Swarojgar Yojana similarly has a preference for women in creating employment opportunities. Article 39D of the Constitution of India provides for equal pay for equal work for men and women. This has been reflected in wage policy of the government, whereby from the very lowest level, where the minimum wage fixed is same for both men and women, and up to the highest levels, equal work is accorded equal pay. Article 15(a)(e) of the Constitution is part of the fundamental duties of each citizen. Among other exhortations, there is also one which requires the citizens to renounce practices that are derogatory to the dignity of women. This has also been incorporated in several legislations over the years. Some of the examples may be given within the Indian Penal Code itself, where it is unlawful to outrage the modesty of women, and we may see several other examples in other legislations, such as the Indecent Representation of Women Act. The 73rd and 74th Amendment have brought in a sea change in the area of local self-government in India. What makes these notable for women is the fact that seats have been reserved for women under Article 243D of the Constitution in all the local self-government institutions. There have been several other legislations which are in design and operation meant to be in favor of womankind. We shall here see some of the most important among them. The most important and probably the oldest concern of welfare policy makers among the social legislations in favor of women was the Sati Prevention Act. There have been several versions and pre-promulgation of legislation in this regard. The latest one has been passed in 1987. The practice of sati is a social evil that our country has seen for a very long time. Under this practice, widows were burnt on the same funeral pyre as their husbands. This was supposed to bring spiritual well-being to them, and they were to be revered as icons of chastity. This was seen as inhuman practice, and at times women were even forcibly burnt on the same funeral pyre as their husband. The Commission of Sati Prevention Act of 1987 declares several acts linked to sati also to be offences. Firstly, it is an offence to attempt to commit sati. Secondly, it is an offence to abet the commission of sati. Such abetments include helping a woman to commit sati, including the belief that committing sati will bring some spiritual upliftment or betterment to her. Encouraging a woman to stick to her resolve to commit sati, participating in a procession for sati, being part of the ceremony of sati, preventing the woman from saving herself, etc. Glorification of sati is also an offence, and the administration is empowered to remove temples or structures that glorify sati. You can clearly see that a very strong legislation has been made to ensure that no one who even remotely engages in anything to do with sati can escape the grip of the law. But you can also understand that efforts to remove sati have been going on since the days of Raja Ram Mohan Roy, and as a matter of fact, even before that, there were kings in India who tried to end the practice of sati. What is it that makes the practice of sati so persistent? What is it that stops this social evil from leaving the society in which we live? This is a question which you can think more about. This is a question on which you can read extensively in history books in India's social conditions and what caused these things to happen. Reverting back to the legislation on sati, special courts are to be created for swift resolution of cases under this legislation so as to expedite legal proceedings. Another important legislation that is in force is the Dowry Prohibition Act 1961. The system of giving dowry to the groom or his family at the time of marriage from the bride's parents is known as dowry. The pervasiveness of this system has caused some problems, as it often leads to familial tensions, as dowry is expected from women, and women often have to bear the burnt of the frustrations of the husband or the in-laws for not having supplied a sufficient dowry. If you remember our discussion in the beginning of this lecture, we said that female infanticide is a big problem. One of the biggest reasons is that women are often seen as a burden on the family because of the expenses which would have to be borne in marrying them off in the form of their dowry. It therefore becomes clear that dowry is not only an evil which affects women when they are young and families when they have to marry their daughters. it is an evil which forces many other evils to spring up. The Dowry Prohibition Act is an attempt to end this practice and the ill effects thereof. The various provisions of this legislation make it an offence to solicit, demand, or advertise dowry. It is also provided that dowry, where given, should be registered and should not be used for the benefit of persons other than the wife and her children. The statute is extremely important and is also notable because of its peculiar provisions in relation to burden of proof. Burden of proof means if a case goes to the court, which party would be required to prove its innocence or guilt. In the ordinary course, it is usually upon the prosecution, which is the people who are pursuing the litigation, to prove that they have enough evidence that the person accused has actually committed the offence accused of the case. However, this burden has been shifted in the case of Dowry Prohibition Act. The burden is reversed. The provision says where any person is prosecuted for taking or abetting the taking of any dowry under section 3 or the demanding of dowry under section 4, the burden of proving that he had not committed an offence under those sections shall be on him. There is a special set of civil servants named Dowry Prohibition Officers appointed expressly for this purpose. It is the duty of these civil servants to carry on the work of dowry prohibition. Apart from this, there are provisions governing the presents given at the time of marriage. You might at this stage ask, what is the difference between presents given at the time of marriage and dowry? Dowry, as it is seen as a crime, has an element of forcible payment. On the other hand, it is not wrong for parents or relatives of a woman to give gifts out of love and affection to their beloved daughter or relative. The list of presents which are given at the time of the marriage to the bride must be maintained by the bride. Now, you can see again there are certain inherent problems in implementing a statute such as this. Oftentimes, people might hide dowry in the form of gifts. Also, this is a problem which has existed for a very long time, and as usual, there are extremely strong social and cultural forces working behind it. It's not easy to do away, to remove, and to finish off these problems by the mere passing of a legislation. What needs to change is the mindset of the people. Let us now look at the Indecent Representation of Women Act. The Indecent Representation of Women Act is another legislation that is important for women. The stated purpose of this act is to prohibit indecent representation of women through advertisements or in publications, writings, paintings, figures, or in any other manner. Section 3 of this legislation provides that no person shall publish or cause to be published or arrange or take part in the publication or exhibition of any advertisement which contains indecent representation of women in any form. It further provides that women's representation should keep with the morals of the society. One of the most recent legislation to protect women is the Protection of Women from Domestic Violence Act. Under this legislation, there are a host of provisions and an entirely new protection system consisting of officers that is set up to curb the menace of domestic violence against women. It is often felt that families, which are supposed to be places of happiness and contentment, are living hell for many women. The reason may be many. The reasons may be many. It is our society is a patriarchal society. Our society is a male dominated society. It often happens that most of the problems of the family come on the heads of the women themselves, and the male members think that the causes of their problems are the women. It also happens that women, because of their physical incapacity or their physical weakness as compared to the men, are forcibly made to do things which they would not otherwise do. All these are examples of domestic violence against women. The legislation to provide women protection from domestic violence covers several aspects. Firstly, it has come to be noted for its broad-based definition of domestic violence. It is important that this definition be made broad. The reason is that only that to confine domestic violence into certain types of acts might not do justice to the spirit of this legislation. The definition of domestic violence under the Act reads thus: the conduct of the respondent shall amount to domestic violence if it harms or injures or endangers the health, safety, life, limb or well-being, whether mental or physical, of the aggrieved person, or tends to do so and includes causing physical abuse, sexual abuse, verbal and emotional abuse, and economic abuse. If such act harasses, harms, injures, or endangers the aggrieved person with a view to coerce her or any other person related to her to meet any unlawful demand for any dowry or other property or valuable security. Through this broad definition, the government has sought to bring in a lot of undesirable behavior under the scanner of the law, whereas it would go unpunished previously. As you can see, it is not only hurting the woman herself which is punishable. It is also punishable if a woman is made to do things or caused to do things by threatening ill behavior with someone she might be related to. It may also be mentioned that in regard to physical abuse of women, the law also provides protection in another aspect, that is, through section 498A of the Indian Penal Code. After various judgments and amendments, it has become a very, very powerful provision in the fight against physical abuse of women, and it has a mandatory arrest provision which acts as a powerful deterrent against cruelty towards women. The infrastructure that is set up under the Act to provide for the protection of women is also extremely important. Without a truly dedicated infrastructure, it might not be possible to fight the evil of domestic violence against women, because the older structures may not respond to the needs of the legislation. Firstly, under the new Domestic Violence Act, there is a cadre of officers who are responsible for enforcing this legislation and ensuring that the women who are victims of domestic cruelty have access to some services and reliefs of various sorts. These are known as protection officers. They are supposed to ensure that women who are victims of domestic cruelty are put in shelter homes and have access to medical facilities. As you can see, the various legislations which I have told you about so far seek to do away with different facets of injustice which are meted out to women. Do you think that legislation alone can do away or change these grave injustices? Do you think there are other forces which need to be corrected? Does legislation change the mindset of people who live in families? And the question is, how many times can the police enter the homes? As long as people themselves do not care for those who they live with, no police enforcement, no system of law enforcement can save the people who live in those homes. It's ultimately our minds and our hearts which need to be changed to truly make the lives of women better and free from compulsion and abuse. The National Commission for Women, set up under the National Commission for Women Act of 1990, needs to be noted at this stage. It is an important apex national level organization with a chapter in every state, and it functions as an executive body that protects the interests of women. Its activities include generation of legal awareness among women, thus equipping them with the knowledge of their legal rights and with the capacity to use these rights. The biggest problem in enforcement of laws regarding women is their own lack of understanding of the strength which the law imparts to them. They need to know their rights, and they need to know when they are being abused in the name of family, in the name of closeness. Secondly, the National Commission for Women also assists women in redressal of their grievances through pre-litigation services. Pre-litigation services include all such services which are given before the litigation stage of the particular grievance. Another activity of the National Commission for Women is facilitating speedy delivery of justice to women by organizing Parivarik Mahila Lok Adalats in different parts of the country. Other than this, it also seeks to review the existing provisions of the Constitution and other laws affecting women and recommending amendments thereto, any lacunae, inadequacies or shortcomings in such legislations. It also seeks to organize promotional activities to mobilize women and get information about their status and recommend paradigm shift in the empowerment of women. It also seeks to investigate and examine all matters relating to the safeguards provided for women under the Constitution and other laws. It also seeks to review from time to time the existing provisions of the Constitution and other laws affecting women. It also seeks to take up cases of violation of the provisions of the Constitution and of other laws. Apart from all these statutory protections, protection for women has also come in the form of judgments from the Supreme Court. The Supreme Court judgment in Vishaka versus State of Rajasthan is hailed as a landmark case because it literally lays down the law in the area of sexual harassment of women in the workplace. It is in pursuit of this judgment that many workplaces have set up bodies to prevent sexual harassment and have regularized rules for prevention and to take disciplinary action after due inquiry in the case of instances of sexual harassment. This judgment gave the women power to lead their professional lives with much greater ease than they could have before this judgment. Women are fast catching up with men in the race towards development. Today, we are at a glorious chapter in the history of our country where the Speaker of the Lok Sabha, the President and the Chairperson of the ruling party are all women. Every day, we read of women breaking through one or the other male bastion. Despite all these achievements, there has also been bad news coming through from the census. The skewed sex ratio and abysmal child sex ratio points towards a dark future. Gandhiji has said that a society may be judged solely by the way it treats its women. If we are to become successful as a society, we cannot continue in the manner we are right now.